Good afternoon and welcome to this session on Towards a European Production Order. We'll get going and I'm sure that others will join us as we progress. First of all, I should say who I am. My name's Iain Mitchell. I'm a member of the bars of both Scotland and England. I'm a QC in Scotland, a barrister in England. I serve on a number of committees. One of them is the IT panel and the GDPR subgroup of the Bar Council of England and Wales. But primarily I'm here today in my capacity as chair of the CCBE Working Party on Surveillance, which is why, somewhat puzzlingly, if you look at my details in the programme, it says I come from Belgium, because the CCBE is, of course, based here in Brussels. The CCBE is the Federation of Bars and Law Societies of Europe, and we're actually going to be having another session on Friday morning in this venue as well. We've got something like 45 members from all across the Council of Europe member states, and we are collectively the bars and law societies whom we represent over 1 million European lawyers. We've got a discussion about the European Production Order, which is an initiative of the European Commission. And I think we've got a really, really good panel to discuss it. We have Tania Schroeter. Tania, would you wave? That's right. Who is Deputy Head of Criminal Procedure at DG Justice. And she's been dealing with electronic evidence since 2016 and is co-chair of the task force on electronic evidence between DG Justice and DG Home. We've got Joe McNamee, who's the Executive Director, Joe, if you'd wave, if you don't know him already, the Executive Director of European Digital Rights, which is a very prominent NGO, and I'm told he's immensely knowledgeable about all of this. Rita Balogh is Google's public policy and government relations team, member who's responsible for data policy. She's a certified information privacy professional, and she's got a particular background in law and international relations. We've got Katalin Ligeti, who is a professor of European and international criminal law at the University of Luxembourg, and her particular area of research has involved looking at police and judicial cooperation in criminal matters. And last but not least, our moderator, Paul de Hert, who is from the Flemish University of Brussels, and he has, besides his obvious claims to fame in connection with this, I note got a background in law, philosophy, and religious sciences. By a bizarre coincidence, I'm a lay preacher in the Church of Scotland and serve on the Ethical and Spiritual Development Panel of the Worshipful Company of Information Technologists. So if the conversation flags, he and I can talk about theology instead. But I assume the conversation is certainly not going to flag. I want to start with a few thoughts to get us going. The problem, because if you want a solution, you have to identify the problem. The problem is essentially the changing world where evidence is becoming increasingly disembodied. In the old paper world, days before information technology, the system of mutual legal assistance was a perfectly workable system because, after all, one is looking to recover bits of paper that are physically situated in offices physically situated in jurisdictions. But with that disembodiment of the kind of evidence which is being used, that's a system which arguably is becoming no longer fit for purpose. Certainly, problems include delay, it's cumbersome, and it's ill-suited to the world of electronic evidence. And that is perhaps part of the background for the European Commission's proposal for a European production order. They, as you will know, published a public consultation on improving cross-border access to electronic evidence in criminal matters, and the outcome is the proposal for a European production order. But the question which the Commission itself acknowledges is, how can we produce an efficient and an effective system which nonetheless guarantees fundamental rights? Now, the CCBE responded to the Commission consultation and has in fact had discussions with the Commission where, because of the nature of our background, we've particularly focused on this question. We are concerned, obviously, about protecting the rights of privacy rights of individuals in general, but our specific concern is the protection of legal professional privilege and professional secrecy, which under Article 8 of the European Convention of Human Rights enjoys increased a protection than normal private correspondence, and of course an absolute protection under Article 6 of the European Convention of European Rights. But of course our concerns are wider than the LPP professional secrecy issue which the CCBE has taken up. There is the CCBE, looking at this, made in its response paper a number of proposals. One is to look at an equivalence of protections in the real world and the virtual one. Most member states have got a fully developed system which adequately protects privacy rights and human rights. For example, some jurisdictions, not as it happens the United Kingdom, but some jurisdictions have systems whereby if a search is conducted in a lawyer's premises, the pétonnier has to be present. Well, that's not terribly easily transferable to the electronic world, but one we suggested should be looking for an equivalence of protection. We need clarity when whether the request is directed at service providers who may be different from lawyers. A lawyer might be in a position to assert professional secrecy, but how does a service provider know about it? There should be guarantees of fundamental rights which are not capable of being circumvented and should guarantee the inviolability, particularly of the Article 6 right. Now, the last thing I'm going to say before I open it up to our speakers is that an interesting discussion can be had, and an interesting discussion I'm sure will be had by us all, about how one deals with that in the purely European context. This is, after all, a session about a European production order, but I don't think we should forget the wider international context. There are issues which arise, both within the European context and in the international context. For example, what if the matter in respect of which the order is made by a requesting state is not a crime in the receiving state? What happens if there are different privacy and other fundamental right protections? I'm not here talking the GDPR, but, for example, back to privilege, lawyers' privilege and professional secrecy is universal. But some jurisdictions have a privilege for priests, journalists, and out with the EU context, the United States has protection for accountants. How does one actually accommodate a circumstance when there's a mismatch between the protections in the requesting state and the receiving state? And finally, does there need to be some kind of mechanism to cross-check these issues? These sorts of issues arose in the US against Microsoft case. We're not going to, I think, have a full discussion of that, but it's useful. But the CCBE did put in an amicus curiae brief, and I know several of the other bodies, including the European Commission, likewise did so. And it may be that some passing reference to the Microsoft case might serve to cross-fertilize our discussion. but I think I'll leave a detailed explanation till we get into the discussion. And then the other thing that's worth mentioning is the mapping project proposal for an international a legal instrument for the exchange of evidence, including in Article 15, the proposal of setting up an international data access authority. Well, it's a different context. It's not necessarily a context that is transferable to the EU, because after all, in the EU, we start from a presumption of a higher level of reciprocal trust, but all of these must inform our discussion. So let me then articulate the questions which are in your program before I hand over to the series of contributions from our speakers and then an open question and answer session. And first of all, how can EU legislation address the challenges faced by law enforcement? I hinted at that by talking about the disembodiment of evidence. What fundamental rights guarantees should it take into account? And then, with an eye to the international context that I referred to at the end, what global precedents do we hope to set? So, over to Paul de Hert to kick the discussion off.
Thank you, Iain. Ladies and gentlemen, I'm a moderator. I'm going to ask questions. I'm not going to say too much. But what I understood today, we already had the Sophie in Veld panel on these and other issues. And what I understood is that the data protection community and the policy community and all those present, you can't deal with these important issues in just one panel. And it's good to have several people expressing themselves. And I hope many more other people will speak out on these issues. I'm myself in a learning process. I'm very familiar with international cooperation in criminal law as it used to be, but this is targeting us in the 21st century at a speed that I'm not used to, and I'm very happy to have to be in this panel after having witnessed the other panel. We complement nicely the other panel. And one of the reasons that we complement well is that we have somebody from the Commission present, and I'm very interested in hearing Tania about the initiative of the Commission. Please, the floor is for you.
Thank you, Paul, and good afternoon, ladies and gentlemen. I'm gonna give you a little overview of our reflection, but without yet disclosing any details of our proposal, which is not yet adopted. So I count on your understanding for that. Iain started by describing the problems that we are facing and the challenges today when we look at access to electronic evidence and criminal proceedings. And let me just complement that those explanations by saying that MLA procedures take an average between 10 months and a year. We now have the European Investigation Order, which entered into force in May of last year, which makes procedures in the EU faster, but we are still at 120 days. And when you think about the way investigations work and how important this electronic evidence can be for the investigation, often this takes place step by step, and in the first step you have to identify leads, to identify a possible suspect, and then based on that you follow up and there is more evidence requested. So it's often repeated requests for electronic evidence that are necessary, and so every let's say process that takes very long is a problem for these investigations. And as Iain has already pointed out, in the field of e-evidence, we are very quickly in the international field because the evidence is stored somewhere else, or because the evidence is stored by a provider who is not an EU provider. So yeah, very often you are in the international domain, and the cooperation mechanisms that we have there, the MLA and now the EIO, are slow and cumbersome. And what happened actually in the last years is that we have seen a new channel developing that has become now one of the most frequently used one, and it's because US providers can actually share non-content data with foreign law authorities directly without going through an MLA procedure. And this is a very fast and efficient channel. But on the other hand, it's a voluntary mechanism, and there is no real legal framework for this mechanism. So practitioners find it very unreliable, and you don't know in advance what the result will be. The service providers are not really acting in a clear legal framework, so it's also unclear for them. Should they provide the data? When should they refuse it? So there's a lot of issues surrounding this voluntary cooperation that takes place already today. And as a result, we see that many member states have started developing their own solutions and responses to the problems, and including very extensive interpretations of national jurisdictions. And we have more and more now situations where there are conflicting obligations also for service providers as a result, and a risk of legal fragmentation. So this is a little bit the background why we have started being interested in this topic, and the Council has asked us in 2016 to work on this topic. And so we have taken the time to speak to stakeholders. We have had a long consultation procedure, and as a result, and we have published several papers. In December of 2016, a first paper on the problem definition, and then in June of last year, some ideas to move forward. And our idea is that we need a combination of solutions. We are proposing to pursue a set of practical solutions that will certainly also improve the situation, but we also came to the conclusion that there's a need for legislative responses, because many issues are also linked to the legal framework or the absence of a legal framework. And so I will not go into these practical solutions, but go immediately to the topic of our panel today, the European Production Order. One idea is that we look at the possibilities to establish a framework that would allow judicial authorities in the member state to directly address service providers which are not established in their member state but in another member state, to obtain electronic evidence from them, no matter where this evidence is stored. So as I said, this direct cooperation with service provider already exists. Today we have the model of this voluntary cooperation, but we want to put a clear legal framework on this, and while maintaining the speed and effectiveness of this form of cooperation. And we think that all stakeholders alike will benefit from the increased legal certainty that the proposal will bring. Now, we are, of course, conscious of the sensitivity of the data in such situations, and our aim is, of course, to find the right balance and to come forward with a balanced proposal that takes into account the needs of law enforcement and prosecution of crimes, and their need to access evidence quickly, but on the other hand also protect the fundamental rights of those affected, including the individual rights in criminal proceedings, but also, of course, the rights to privacy and personal data protection. Now, because the direct cooperation departs from the traditional way judicial cooperation takes place. In a judicial cooperation, normally you have an authority involved in the issuing state, and you have an authority involved in the so-called executing state where the measure takes place. And then the two authorities have certain conditions, obligations. The executing authority has a role in reviewing this measure and can refuse it under some conditions. And we want to do a shortcut here. So by getting rid of this authority, by directly addressing the service provider. So you can imagine that this creates quite a few challenges in terms of how to ensure safeguards and fundamental rights. So that is actually one of the focus of our work, is to see how we can ensure that the rights are respected. So we are looking at what conditions should there be for issuing such orders, what should be the involvement of the host state in the procedure, should it be involved, if yes, when and how, and then of course what should be the remedies for the various actors involved. So for example, one of the also very important question is, what role do you give to the service providers? No doubt Rita will also have a word about that. But do you give do you delegate the role of the judicial authority to the service provider to review this order, or on the other hand, do you say no, this is not the role of the service provider? The service provider should just execute the order, or shall we find something in between, saying okay, there are certain situations where also to protect the service provider's rights, you should be able to challenge that order. So then, of course, as in every international situation, you have the question, if there are legal remedies, where should these remedies be exercised, in which state? Iain also mentioned the problem, of course, of the immunities and privileges that can arise in such context. So that's just an overview of the different issues we are looking at. Another very important issue for us is also trying to avoid that companies are made subject to conflicting legal obligations, so-called conflicts of law situations, where we would impose an obligation on them to respond to an order, but they would be prevented under the jurisdiction that they might be under to disclose that data. So we are looking at that issue as well. So we continue to work very intensely on this complex file to arrive with a proposal that would be ambitious, but at the same time legally sound. And even if I can't give you any indication of the precise timing yet, we hope to deliver it very soon. And last but not least, let me also say that we are also aiming to ensure consistency with the ongoing work under the Council of Europe's Cybercrime Convention Committee on an additional protocol. And we are, of course, also keeping a close eye on what happens in the US. Thank you very much.
Thank you. This is most informative, and I think with these kind of new developments, bringing information is very relevant. If you don't mind, but I would pass the floor immediately to Joe. There was you talked about a participatory process and so on. So I think Joe is well prepared to give his views on this development, and then the audience can then judge whether my decision not to raise questions now was a good one or not. Joe, please.
Thank you very much. I'd like to come back, first of all, in helping set the scene. There were two statements from Tania that I will try to correctly reflect, and you can correct me if I'm wrong. One is, you said that, for example, one example of the data was to identify a possible suspect. That's not evidence, strictly speaking. So should we be talking about cross-border access to data rather than cross-border access to evidence? Because it seems to be broader. I can see the political value of saying it's evidence, because that raises the blood pressure of people who think that bad things are bad, and they are. The other thing I would like to focus in people's minds is that you questioned whether it would be a good idea to hand over a previously judicial task of receiving the order into the hands of private companies, whether it be Google or a tiny company, handing over judicial tasks to private companies. So to start with, the process that we've had with the European Commission in its consultation and its discussions, it has been more open, more honest, and more responsive than, particularly in relation to DG Home, we're used to better standards from DG Just, has been better than anything that I've experienced for a long time, so credit where it's due. If you don't understand your history, if you don't know your history, you're likely to repeat it. So I think it's important to understand that this is not a standalone item on data in the middle of a desert of policy. There's been a lot of policy in relation to retention and use of data. We have a habit of doing the same thing over and over again in Europe with regard to data and expecting different outcomes, which I think Einstein said was the definition of insanity. And we do this mainly because of politics. There's an urgent need to do something because politics. In 2005, in the historically last United Kingdom Council presidency, the Commission came under huge pressure to launch something, anything, please, on data retention, and it launched the Data Retention Directive. One of the justifications that the Commission gave at the time in the impact assessment for needing the Data Retention Directive, the illegal, demonstrably, obviously illegal Data Retention Directive, was that mutual assistance between member states was really difficult. It was slow. So we needed to hack, we needed to find, as Tania said a moment ago, a shortcut. We needed in 2005 to find a shortcut to the problem of member states cooperating. And in 2018, we're looking for a shortcut to solve apparently the same problem. The Commission claimed that the Data Retention Directive was legal. Commissioner Malmström, bless her, she put out a press release saying that she was vindicated when the court said that it was illegal. The Commission tells us that the various PNR instruments are legal. And then the court ruled against the least intrusive instrument, saying that one was illegal, the EU-Canada agreement. All of the PNR agreements are still in place, even though the weakest one has been ruled illegal. The member states in most countries have retained data retention, even though the court has said it is illegal. Now, in 2018, we're going to have cross-border access to data that is illegal according to the European Court of Justice and unconstitutional in certain member states because of the legacy of reckless legislating in this area. So in 2005, as I said, in the impact assessment of the Data Retention Directive, we were told that one of the big problems to solve was cross-border access to data. Then in 2011, they published, well overdue, they published the implementation report of the directive. And guess what? Fewer than 1% of the cross-border, of requests for retained data turned out to be cross-border. So the problem that we were trying to solve in 2005 wasn't even a problem 6 years later. Now, apparently, we're trying to solve the problems that haven't been solved by the European Investigation Order in the 247 days that that's been in force. And we're trying to circumvent the international data sharing problems that appear to be the same problems that we've had in the 4,508 days since the Commission first said that we needed a shortcut to solve that problem. The issues in this area, and here I have a lot of sympathy, both politically and practically for the Commission, the issues are really complex. And even within the EU, even before thinking about international issues, the proposal is fraught with practical and legal challenges. And that's why we need a minimalist approach. We need to identify the key problems and deal with them in an efficient, legal, and durable way. There are various options for dealing with this data already. We have a basic principle of least restrictive alternative when restricting fundamental rights. We need to establish the hierarchy and respect the hierarchy. Between the technical problems, the legal problems, the political problems, the Commission had to delay its proposal. It has internal turf wars, it has interference from member states, it has confusion regarding how to deal with illegally retained telecommunications data, failure to understand what needs to be addressed in addition to the European investigation order. It's got a history of illegal proposals from PNR, data retention and others. And as if all of that wasn't bad enough, it's trying to legislate in the midst of the movements happening thanks to Microsoft Ireland and thanks to the Council of Europe. The Council of Europe process starting before the Commission launches its proposal and finishing after the Commission launches its proposal, but running in parallel. We need to be very careful of several points. Extraterritoriality of the directive, mutual legal assistance of foreign jurisdictions is entirely inappropriate. It's inappropriate because this is supposed to be, I believe, a minimum harmonization measure. It's also inappropriate because the Commission itself, in a very good and warmly to be recommended progress report that it published, has identified low-hanging fruit for IMLAT reform. And it's also inappropriate because it's very easy to diligently, correctly implement mutual recognition. But politically, it would be very, very difficult to withdraw it again. We can't even suspend the Canada PNR agreement, which is a fraction of the complexity. Secondly, and this is something that will be of concern for the companies as well, notification of the user concerned must be given ex ante, ex post if it absolutely has to be ex post. Notification to the concerned state or states must take place automatically, and we have to get away from the habit of exceptions being the rule in European politics and European legislation. Providers should not be held liable, particularly for saying no. It's one thing, with all due respect for Google, it's reputed that they have more money than some of the smaller companies. A smaller company in the middle of nowhere in Europe getting a production order from Hungary is not necessarily going to know what to do and should have the right to be diligent if that's needed. In the same vein, it's important, again, for smaller internet companies and for diligence to have cost recovery so that smaller companies can challenge, can research if they need to. And this is a restriction on rights to privacy. So the restriction needs to be demonstrably necessary and proportionate and genuinely achieving the objectives of general interest that it aims to achieve. If you look at the European Commission's dreadful implementation report of the Child Exploitation Directive, you can see just how far we have come from the notion of demonstrably achieving objectives of general interest. The Article 29 group has questioned whether basic thresholds of necessity have been reached. We would tend to agree. We need an instrument that achieves what the Data Retention Directive and the EU PNR and individual agreements fail to deliver, a text that can survive being challenged in court. We need a text that is sustainable politically, if it's necessary, and we need a text that's sustainable in court because we can't keep breaking the law on the basis that we need to uphold the law. Thank you.
I have a feeling you raised many questions. Tania, you want to go in some of them, or you want to take a break and breathe in and breathe out? Yeah, go ahead.
Yes, just to react quickly to you did. So I totally agree, and I think my colleagues as well, on your last reflection that we need to come up with a proposal that will withstand scrutiny in Luxembourg. But let me also say that we are learning from every judgment that the court delivers, and we are drawing the conclusions to avoid that this is repeated. So This is all I wanted to say. And another thing is that the problems don't go away. You know, just if we don't legislate, the problems will persist. And so are these problems not important enough that we act? I mean, up to discussion.
I like this little chess playing moves of both. And what I also like about CPDP, we're a multi-stakeholder conference and you never know who's tangoing with whom. Eh? And so, Joe, you surprisingly said so many nice words about private actors and providers and Googles. So we have somebody next to you who's working for Google, Rita Balogh. You have a lot to say. I probably think you like the immunity aspect that Joe was advocating for, and but perhaps I can't guess your thoughts. So go ahead, enlighten us.
Thank you so much, Paul. Yes, I do agree with some of the things he said. I think I provide obviously a different perspective on some of the things. The bottom line that Iain mentioned, that Tania mentioned, that Joe mentioned, that we need to recognize that there is legitimate interest from the law enforcement side to access data, to solve problems, to fight crime. I think we're all agreed to that. The other theme that I wholeheartedly sign up to that came out of all of the interventions so far is we also need to have a process that defines access to this information that is clear, that is transparent, that respects the fundamental rights. The one aspect that I will also emphasize in all of these discussions from our perspective is the interest of, sovereign interest of countries who are involved, and Joe also alluded to that we need to take that into account. The solutions that we're thinking about are both legal, national, international, but also practical. So let me say a few words. Obviously, being headquartered in the United States, we have been very active part of the legislative debates there. I think we were one of the, talking about history, one of the first, if not the first company who pushed very hard for the ability to disclose transparency reports about how many requests we're getting from the law enforcement side, and we actually we have a booth. This is part of probably my marketing exercise here. You can ask the colleagues; they can show you this transparency.google.com website, where you can see breakdown per country of how many requests we're getting, and we've been publishing that from 2009. So transparency from our perspective is a very important aspect. We have also been part of other legislative discussions, such as the ones that are pushing for more safeguards, higher standards, higher legal standards to access data that is held by companies. And we've been also pushing for changes in the legislation that more vehemently recognizes the sovereign interest of countries, including countries from Europe. We've also been active in Europe in this debate, and we were invited to the stakeholder consultation. And I want to second Joe that this was one of the most professional processes I've seen, with people truly interested in trying to fully understand all sides of the debate. So it was a very interesting exercise for us to be part of that process. The interest that the company is showing is pretty obvious. Since we started to publish the transparency reports, the number of requests that we've seen went up pretty dramatically. The first report from 2009, and these are always half a year numbers, but the first report was about 12,000 requests that we got. The last report that we published, which covers the first half of the year of 2017, it shows almost 50,000 reports. And we also see a trend of getting these requests from more and more countries around the world. In terms of Europe, I think the rough aggregate number is about 20,000 that we got from law enforcement authorities in half a year in 2017. Now, when you think about Google, who, like, for example, if you think about a product like Gmail that has over 1 billion users worldwide, these numbers seem tiny. But if you just look at the absolute numbers, they're still quite significant. Especially that we have a team who I don't know. We definitely set the standard that we have a team that evaluates each and every one of these requests. And we evaluate that against international human rights standard, against Google's own policies, as well as the legal requirement that either we or the requester authority is subject to. So as these requests are becoming more international in the sense that there are more and more countries who send us these requests, we do believe that we need to take a look at the international legal framework, national and international legal framework. And we believe that there are three things that these laws and treaties need to balance. The first is recognize the need that law enforcement need to get access in a timely manner to this data. But these laws also need to provide the fundamental rights protection, which should be a fairly high standard, or if not very high standard. And it also needs to take into account the sovereign interest of the countries whose citizens or whose residents or where the people are staying. The traditional answer that everybody is alluded to were MLAD, or government-to-government solution, but really the mutual legal assistance treaties. And these are good from our perspective because they allow countries with different values to cooperate in a way that still respect those values. They're also very important tools for companies who are dealing with requests from countries with varying, different human rights and due process standards. We do not want providers, we definitely do not want Google to find ourselves in a situation where disclosing the data means, repressing a human rights activist, where, an authoritarian government would come to us and use that information with an abusive, repressive aim. And mutual legal assistance treaties are really good tools to kind of protect the companies, protect its users against such abusive requests. However, we also recognize that MLAT doesn't necessarily work all the time. Someone mentioned the 10 months waiting period, that someone says it's an average, someone says it's as much as, but it's definitely many months that you may need to wait for your request to be evaluated. This is a challenge is coming from, as far as we understand it, from the increased volume of the requests. Google is not the only company and US company that gets this amount of requests. It's also a lack of automation. It's also a lack of understanding of what you need to put in an MLAT if you want it to get through the system. This clearly can jeopardize an investigation. This is not always the case. You don't always need to use MLAT. As Tania alluded to, there are emergency situations where someone's life is in danger, or there are certain categories of data. But as a principle, a lot of these requests are going through MLAT. So while we need to preserve MLAT, which is, as I mentioned, a very important protection tool as well, we also need to find solutions. The solutions that we're kind of thought could be effective are, most of all, training. And we've seen over the last 2 years, and I think that's also coming out of the stakeholder process that the Commission has organized, more and more requests for us to provide trainings for law enforcement authorities around Europe in a more and more organized way, which is very welcome. There's also dedicated funding from the European Commission that would help officials to better understand the MLAT process. We've also asking on the other side of the Atlantic for modernization of the MLAT process so it can better handle the volume of the information that they need to deal with. And last but not least, we need to, while keeping MLAT, we should think about solutions to supplement it. I do want to second some of the do not do's that Joe was saying. What we think that the kind of solutions that we do see emerging that we do believe should be avoided are indeed extraterritorial implications of legal requirements. I would add to the list of Joe, really aggressive enforcement efforts that basically try to circumvent due process mechanisms that are out there, like the famous question of direct access and so-called lawful hacking. There are other countries who are putting forward data localization requirements as a solution to the quote-unquote MLAT problem. We don't believe that any of these provide real solutions. In our opinion, mostly they limit rather than improve the efficiency of the cooperation. They're definitely lower fundamental rights standards, and they definitely set a dangerous international precedent. So I agree that many of these should be avoided, all of these should be avoided. Where we do think, you know, on the positive side of things, or what we could do, we do believe there is a need for legislation, and we obviously saying that from a global perspective, from a company who's also active on the other side of the Atlantic. As I said, we are actively promoting legislative solutions on the United States, which would accommodate the sovereign interest of countries, the sovereign interest in protecting their citizens and residents' fundamental right. We do believe that what really defines this sovereign interest, or triggers this sovereign interest, if you will, jurisdictional claim, is really the user, the citizenship, or the location of the user. We also, as Tania said, we do see a lot of requests coming to us directly, and our General Counsel made it very clear last year that we would be open to a solution that allows for authorities to come directly to us, but this needs to be based on you know, democratic countries with high human rights standards, with good due process standards, and it should not be a grab all. And then the only solution that we can achieve that is really international agreements. John mentioned in the previous panel the US UK agreement, which kind of sets a framework for such a direct access, which also provides strong safeguard for such a direct access, in a sense that the possibility to directly come to a company with a law enforcement request. And as Tania mentioned, we understand that this is what the Commission is trying to achieve, but at an international level, whatever the Commission is doing in Europe, we strongly believe it needs to be supplemented with an international agreement to bring in actors or deal with actors outside. And despite of the long list of court cases that Joe mentioned, like from our perspective, the EU and the US are well positioned to try to find a good foundation for such an agreement. The other thing that I would add is the solutions complementing these legal international solutions. There are practical solutions as well that we should think about, and Tania mentioned that is also part of the Commission stakeholder consultation process to try to figure out what really low-hanging fruits, practical steps that we can do or take that allows more efficient cooperation between providers and law enforcement authorities, but still also safeguarding the due process and other protections that is out there. The solution that we've seen that works very well is the single point of contact, or SPOC system. This is where, you know, law enforcement authorities designate certain officials who understand the MLAT system, who understand how it works, what they need to put in. They also understand companies' procedures. So they're actually very savvy about the legal and formal requirements, which make their request more efficient. It's also very helpful for companies, like as I mentioned in Google's case, and Joe certainly is right in saying that it requires a lot of resources. But in our case, we do evaluate the national legal requirements from every country where we get these requests from. So we do kind of look at, okay, that person who's submitting the request, does he or she have the legal authority under their national procedure law to actually submit that request? And when you have a single point of contact, that makes it more straightforward, because then we know that that person has the legal authority to submit that request, and that could also help smaller companies who do not have that the level of resources that we admittedly do have. And again, there has been improvement in that front. We see more and more a single point of contacts, more and more authorities interested in it, and it's not least because the European Commission and Europol is pushing for that. So in terms of conclusion, and at one point, Paul, I'm happy to come back with some of the safeguards that Joe mentioned that we also advocated for quite heavily in the process around redress and notice and and others. But basically, we believe it's not a one-size-fits-all solution. We need a combination of solutions. We need a better MLET system that functions better, that is supported by training. We need practical ways like the single point of contact that can provide meaningful short-term solutions to these problems. We do need legislative solutions. As I said, we're promoting those on the US side as well. And then we do need, because of the international nature, we do need international agreement, bilateral, multilateral agreements that can help us solve this problem.
All right, food for thought. Thank you. And sometimes I'm happy there's a transatlantic dimension, because this keeps us away from amateurism, in this case, I hope. We had a cold shower yesterday with Max Schrems, looking at his judgments and case saying that's important. But these things here, that's criminal law. That's actually basic stuff. It's unimportant. And that was a cold shower because I think this is very important too. But it's good to have the perspective of a trained criminal law professor. And that's why I'm so happy that Katalin is here. She's a colleague from me from Luxembourg University. Katalin, please take the floor. And the Q&A is at 5. We won't forget you. It's promised.
Thank you very much, Paul. Good afternoon, ladies and gentlemen. Indeed, I am in my capacity as an academic on this panel, but I have to make a footnote to this. I am a privileged academic in the sense that I've been serving since April this year as a special advisor to Commissioner Jourova on judicial cooperation. So I have been working together with Tania and the task force and the team on the draft, so I'm privy to the draft, which cannot yet be disclosed because it has not yet been adopted. So I would like to put forward that I'm speaking in my personal capacity as an academic. However, having witnessed this process, I think it was a truly remarkable process on 2 counts. First, this is one of the unique occasions when member states request the Commission to come forward with European criminal law, to put forward European legislation. Usually, member states are rather reserved, if not resistant, to European criminal law. So this is just the opposite case, which I think clearly shows that on the one hand, member states acknowledge that this is a global problem. And I think this panel showed many evidence that we have to look transatlantic if we want to deal with this issue. So member states realize that they will not be able to tackle the practical problems that their law enforcement authorities encounter just by a unilateral approach. And we are in the scarce situation where member states look at the European Commission and tell, Commission, come and help us, we need European legislation. At the same time, I think it's also a common understanding, and that also emerged a little bit from this panel, that prosecutors and police should be able to do its job, but we still need robust protection of fundamental rights. I think the second aspect why this process was so remarkable, because as Joe and Rita already said, there has been a very extensive consultation with the private sector, and I think that this will find its blueprint also in the future draft. Now, Joe mentioned that one should not forget one's history, and he rightly reminded us about the data retention directive and everything that came afterwards. I would like to complete this picture because I think this is a part of the history, the data retention legislation, but the other part of the history is the European evidence warrant, which was put forward in 2003, if I correctly recall. And already in that piece of legislation, there was already a provision on electronic evidence, where the Commission did not call it at that time electronic evidence. But already back then, nearly 15 years ago, there was already a recognition from the Commission that we have to deal with sort of digital data and its transmission cross-border. Now later on, the piece on what we today call electronic evidence got cut out from the actual text of the European evidence warrant, because member states thought at that time was not yet ripe to look into this issue. So eventually now we are there, and I think we also have to see that this is also part of the history of this process. As an academic, I shall stay conceptual, and in the very short time that I have, I would just like to point out 3 issues, and I think these 3 issues have been picked up in different ways in this panel. The first more conceptual issue is what we are really talking about. What is electronic evidence? I think that John has rightly pointed to the fact, aren't we talking really about cross-border access to data rather than evidence? Has it been already qualified as evidence? And I think that from a purely legal perspective, that's true. We are talking about access to data. And the question is how we define data. And this is, of course, interesting on a more academic level, but I think the challenge for the legislator that the definition brings along with is really to find a way for a future-proof legislation. A future-proof legislation in terms of data covered and also in terms of providers covered. When we talk about data, and I think in this context there had been a sort of latent understanding that we are talking about sort of communication data, subscriber data, content data, and so on and so forth. But if we think about the different types of data that actually private sector entities may process, acquire, retain, then we have a much broader spectrum. And obviously, whatever legislation will be put forward now in terms of law enforcement access to data, this may serve also as a sort of model, even if not as a blueprint, but at least as a sort of model or approach for all other data, let it be financial data or other data that private entities may hold. So this makes, I think, the conceptual part of the work very complex, and I think that there the European legislator had a difficult time of finding the right way for a future-proof European legislation. The second more conceptual question that I would like to point to is really what is the role of private parties? Here again, the claim has been raised, we should not outsource functions to private sector entities, which are really law enforcement functions. And indeed, the moment when Google's and Microsoft hand over data of private persons to law enforcement, or even look for that, they become a sort of extended arm of law enforcement, what we traditionally call as the SWOT function of law enforcement and the criminal law. But I think it emerged also quite clearly from Rita that there is also a shared function, because private sector entities claim that they have either legal or commercial motives or both to protect the data of their customers. And here the challenge is of finding the right balance and imposing, so to say, or envisaging the right role for these private sector entities. There is certainly a SWOT function, but there is also a shared function, and they are both legitimate. They are also, to some extent, contrary to one another, and it needs to be clearly articulated in the future legislation. The final conceptual point that I touch upon is territory. Does territory matter? In the previous panel by Sophie van Veld, I think an interesting comparison was put forward, that whereas in the offline world, we are usually quite hesitant, if not reserved, to accept that foreign law enforcement can actually go to the territory of another sovereign. We do not want to see foreign police officers on one's own territory. When it comes to the online world, it seems that this reservation is somehow not present or not present in that form, because now we are talking about law enforcement access across territory. So seemingly it has been argued that maybe territory doesn't matter so much in the online contest. I would disagree with this point, and I would actually further nuance it. I think that territory does matter in the online context. The difficulty is, however, how we break down territory in the online setting and how we actually define it. And I think that the future legislation also needs to respond to that, how we understand territory in that particular context. Now, if we look to the future, I think that if the European production order will be adopted, it will certainly take mutual recognition and judicial cooperation to another level or to a higher level in comparison to the other instruments that we have in place today. As Tania correctly mentioned today, all of these mutual recognition instruments work on the basis that there is a contact between an issuing and an executing authority. So there are authorities involved on both sides of the cooperation relationship. With the European production order, we will move away from that concept, and there will be one authority of one member state getting in touch directly with the service provider, so to say, with the private sector entity, just as if this private sector entity was located on its own national territory. So I think that with the European production order, we are really moving towards the direction of a truly European area of freedom, security, and justice. It will have certainly effects, and I would like to conclude with the effects that this draft legislation may have in the future. It will have effects on the authorities. The authorities will be in a position to look which instrument works best for them in practice, and they will have a multitude of instruments at hand. They will have the European investigation order, they will have potentially, if adopted, the European production order, and we have also international instruments. So obviously the relationship between these instruments have to be well defined. Otherwise, we might have a sort of race of instruments. And I'm not even mentioning that we are, of course, talking now very much with the European focus, but there are bilateral negotiations ongoing between the United Kingdom and the US on a bilateral international agreement. And there are also works, as has been pointed out, in the Council of Europe to have an annex to the Cybercrime Convention. So we have to see how all this fit together, and practitioners, we know, they will use what they think is the most efficient for them. And in that respect, I think that fundamental rights and robust protection is very important. For industry, I think that the European production order can bring a lot of clarity in the acute fragmentation and in clarity that we are currently having, but will not answer necessarily all their problems, because as Rita, I think, rightly made the point, the requests are not only European, this is a transatlantic problem, which also means that I think with the European production order, legislative work and the work of the Commission will not stop. We will still, in Europe, need to look for other international solutions to accommodate truly the transatlantic dimension of this issue. Thank you.
Well, we come to the part where I'm going to solicit contributions from the floor, but before I do that, I want to throw another, those of you who know anything about cricket, googly, or wide ball into the mix. Joe and Katalin both raised the absolutely fundamental point, which is what are we actually talking about? And I think we need a degree of clarity of thought here. You see, I'm not sure the distinction between evidence and a data is a valid one. It's comparing chalk with cheese. After all, you can figure electronic material which is not data, which might nonetheless be evidence, and data itself is, of course, evidence in anything you produce in court. You could imagine, for example, computer code in a particular case being evidence, but it isn't data, it's code. It seems to me the distinction is perhaps a distinction, and I didn't think about it when I introduced it because it says we're talking about electronic evidence. There's an important distinction between evidence gathering and surveillance. If you come at it from the UK perspective, and there was a discussion about a roadmap on exchange of electronic evidence in The Hague a couple of years ago, if one is gathering intelligence under the Regulation of Investigatory Powers Act in the UK, it is a specific provision that any intelligence thus gathered cannot be produced in court. So by definition, it isn't evidence, yet still it's an intrusive gathering of material and information. So are we, as the UN paper, the mapping project does, are we talking about surveillance and evidence gathering both? Or are we only talking, in the context of the Commission, about evidence gathering? And I think we have to have proper typological distinctions, and to talk about data is not, I think, helpful, because data may or may not be evidence, and all electronic material, which may be evidence, is not restricted to data. So people might like to think about that a little bit when they throw in the contributions. And I see you formed an orderly queue, at the moment only of 2, so who would like to kick off? The microphone's not on. I think you are now. You're on.
Okay. Tobias Morsches, Datenschutzraum Germany. My question is, you said problems are still there. The question is, the problems in case of civil liberties are still there too. We have a very diverse landscape of interpretation of human rights in several parts of the world. Even in Europe, there are some parts that are not interpreting human rights the same way as in other parts. The question is, what allows under these conditions to come to other or lower safeguards than the MLATs due the production order?
Hello.
Yes.
Oh, yeah.
I think we'll probably just take a question at a time, since there's not a huge queue to contribute. If you start getting really excited, we might group questions, but let's take that one first. Who wants to kick off?
I would not necessarily talk about lower safeguards than AMLAT. What you're doing in an AMLAT is that you are accumulating conditions that exist under 2 national regimes. And I think in the European Union we have gone some way in terms of harmonizing minimum standards in criminal proceedings. We have mutual trust. So we have also something to build on, so that we can go further and say, okay, we only take into account, we agree on a set of conditions that must be fulfilled for this this production order to be valid, and then we accept it in all the member states. That's the idea behind it. But we agree as a starting point on the level of safeguards that we need. and based on that, we can work. Whilst, you know, the mutual legal assistant is a different logic. You don't have harmonization, and every country is there free to ensure its own national system and its sovereignty.
Joe, I think you want to come in.
I'm not sure that saying that we all have the same minimum standards means that we all have the same standards. And if a country with lower standards than your country is asking for the data directly to the enforcement authority, then you are getting lower standards than the democratically agreed standards of your member state. There may be less difference between the EU and third countries, but we don't have regulations governing all of this, so we don't have identical standards. Personally, looking at the never-ending saga of data scandals from the Irish police force, the whistleblower scandal most recently, certain other member states in the centre of Europe, I get shivers when I think about the standards that will be respected, with no offence to anybody sitting on this panel from member states in question.
Okay, we've got 5 minutes, so I think we'll take these 2 questions together so we don't miss anybody out, and then we'll have an unseemly scramble to answer them in about 4 minutes flat.
Thank you very much. I'm Gloria González Fuster from the so-called Flemish University of Brussels, also known as the Free University of Brussels. And my question is about this remark that we will move to the real European area of freedom, security and justice when we just give up the executing authority. And there was a mention that we are learning from the judgments that come from Luxembourg, and perhaps we are not reading the same judgments, but I wonder where do we learn that the mutual trust is about blind mutual trust? I think that the judgments that are coming from Luxembourg are not saying this, you have to get rid of executing authorities. Actually, there is a role for executing authorities. Their role is basically to make sure they have this shield function of making sure that fundamental rights are actually respected. If that's the message from Luxembourg, why taking this shortcut? Who is obliging us to take this shortcut?
Okay, and next question.
My name is Walter van Holst, Vrijschrift in the Netherlands. I was reading the impact assessment for the e-evidence proposal, and this tickled my curiosity a bit because it's relying on statistics from transparency reports. So, am I wrong in concluding there's no statistics whatsoever on which executing authority performs in what timeline, gets how many requests from issuing authorities, and which member states performs better or not? And doesn't this raise questions about subsidiarity and proportionality if there are member states that actually have a flawless MLET procedure, whereas others probably haven't?
2 questions, really both about trust in a way. First, can we really rely on full mutual trust given the different approaches which have been taken? And the second is, can we trust the statistics we don't have? Who's going to field those?
So on the statistics, I mean, we have to work with what is there. And in the field of criminal justice, there is, in all areas actually, a lack of statistics and a total reluctance, also by member states, to collect statistics. We are making progress slowly, but yeah, we have to work with what we have, and I think in the framework of the impact assessment, we are confident that the data that we have, that was available and that we also gathered, was sufficient to show the problem, the amplitude of the problem, and to support our proposal. In terms of the second question, so the parallel was drawn between the data retention judgments and how we could conclude from that there was no need anymore for an executing authority. But I think the data retention judgment is about the legality of an instrument, of a directive. It doesn't say anything about how judicial cooperation should work. There are conditions in there for access, for retention of data, and for access to such data, and these conditions we are trying to take into account for our proposal. So this is not a contradiction, I think.
Yeah, I think
Okay,
we can squeeze a few minutes.
Okay, I will try to be very brief on statistics. I think there has been many claims made that if there's no evidence, then there is no problem. I think that this is really a shortcut. We very often lack proper statistical data in many respects of European criminal law, so to say. And this is, I think, maybe a symptom of the difficulties of shared administration in the European Union. I firmly believe that the fact that we do not have maybe as comprehensive statistical data as one would wish or as one is accustomed to in a national setting doesn't mean that we do not have a true problem. Mutual trust, I believe it depends a little bit on the interpretation and the reading of the judgments of the court. I don't share the view that the Luxembourg court says that we need executing authorities to check fundamental rights. In my reading of the judgments, fundamental rights need to be checked. And with the Charter of the European Union, I think now we have European standards, and it is the job of national courts to make sure that rights are protected on the ground. In this case, in the case of the European Production Order, I don't see why we shouldn't trust judicial authorities in the issuing state, let's say in the classical terminology, to check fundamental rights. I think that this would be in conformity with the jurisprudence of the Court of Justice in Luxembourg.
Right. Well, we've come, I think, to the point at which we've got to make way for the next panel. It's interesting that actually we come out of this session with more questions than we had when we went into it. But I'd judge the session a success if we're all going away having less certainty in in our own thoughts, because this is a hugely important matter, and it's a debate which is going to continue when we see the Commission's proposals, which I hope will be coming along soon. And I hope everybody participates in what will be a very lively debate, having been encouraged and set thinking by the discussion we've had this afternoon. So I'd like to thank the moderator, the panel, and all of you, ladies and gentlemen, for your contribution, and go off and have a nice cup of tea. See you.